What happens when someone inherits mom or dad's property jointly with their siblings and they want to sell it? It will depend on a number of questions, such as, did they have a will? Is the property in probate? Over the next few minutes, I'm going to share the steps you need to take in the event you inherit joint property and wish to sell it. I'm Mitch Greene, partner of Kramer, Greene, and for the past 35 years, I've helped business owners in various industries, such as healthcare, protect their businesses from unforeseen circumstances. If you're trying to protect your assets or business and need legal assistance, I'd like to help you create that playbook. So visit my website and schedule a complimentary consultation, and I could walk you through your options. When an individual who holds real estate solely in his or her name passes away, real estate ownership passes to the person's heirs through the probate process. Inheritance disputes may result from joint ownership of assets, including real estate, which may sometimes make a partition action or forced sale necessary. One of the most common scenarios in the context of inherited real estate is when siblings jointly inherit real estate from their parents. Siblings who jointly inherit real estate in this manner share joint undivided ownership in the property or as tenants in common. Each sibling has equal rights to the property, and no barrier or line separates their ownership of the property. In most cases, the siblings have no problem deciding what to do with the property. For instance, they may sell the property and divide the proceeds of the sale evenly among themselves. They may even retain the property as investment property or use it as a vacation home by hiring a property manager and dividing any rental profits and maintenance costs. However, in some cases, siblings cannot agree on how to handle the property. One sibling may wish to sell the property and get their share of the proceeds, whereas the other sibling may wish to hold on to the property for sentimental, investment, or other reasons. Even worse, the dispute may become so heated that one sibling may move into the property and not allow the other sibling to enter, or real estate professionals to appraise, inspect, or list the property for sale. Ultimately, in a dispute over jointly owned real estate, the only option is to file a petition action in court to force the sale of the property. The co-owner who wishes to sell the property or the estate's personal representative can file a petition action or a formal adversarial lawsuit in the probate proceedings under Florida Statute 733.814 at any time before the estate is closed. If the estate has already closed and the joint owners cannot agree on the disposition of the real estate, then the co-owners wishing to sell the property cannot file the petition action in probate. In that case, they must file an independent petition action under Chapter 64 of the Florida statutes. A petition action proceeds like any other civil lawsuit under Florida law. The parties exchange discovery requests and court hearings may occur. In most cases, the parties settle either by agreeing to sell the property to a third party on certain terms or by one party agreeing to buy out the other party's interest in the property. If the real estate consists of undeveloped land, the parties can also physically divide the tracts of land instead of selling the real estate. In reaching any settlement, the parties to a partition action must also remember that one or more parties may have paid mortgage payments, property taxes, insurance premiums, or other expenses to maintain the real estate through the proceedings. Those parties are entitled to a credit for 1/2 of those reasonable expenses paid towards their share of the real estate proceeds. If the parties cannot settle the case, the court will generally enter a judgment of partition and order the property to be sold. Typically, this sale occurs via a public auction or private sale conducted by a court official. Any proceeds from the sale, after the costs of the sale are paid, would then go to the co-owners in equal shares after considering whether either party paid maintenance expenses for the property during the proceedings. Keep in mind that by this point, the parties will likely have paid tens of thousands of dollars in legal fees. An easy way to have avoided this situation would have been for the parents to have each form revocable living trust and for the real estate to ultimately be transferred to the revocable living trust of the surviving spouse, thereby avoiding the probate process. The revocable living trust would then name a successor trustee After the parents pass away, the successor trustee would then be responsible for the sale or other disposition of the real estate and could be a non-family member in the case where the children do not get along and would more likely have a dispute regarding their ownership of the real estate. I hope this video provided you with an understanding of some of the issues you may encounter when you inherit real estate from your parents, as well as those things you or your parents could do to avoid such problems. Whether you're trying to protect your assets, start a business, sell a business, or navigate the laws within a business, we provide a one-stop option for everything. If you have questions surrounding your business and legal needs, schedule a time to meet with our firm and take the first step in protecting your business and financial future.